She'll tell us. And you are?
My name is Anne Stevenson.
Okay, thank you.
I did. I submitted written testimony.
Number 30. So, Ms. Richter, you'll now become number 30, okay? All right. Thank you very much.
I appreciate your flexibility.
No problem.
Thank you, Elizabeth. Okay, my name is Anne Stevenson, and I'm a policy consultant and a journalist for the mainstream national media. And I'm going to be offering testimony on behalf of dozens of Connecticut parents who were unable to attend or feared for their family's safety if they spoke publicly about the problems that they encountered in the family courts. I'm not affiliated with any gender specific advocacy groups, but the parents that I'm speaking for, I want to be clear when I say abuse, these are victims of violent crimes and fraud and false billing scams that they've encountered in the family courts. The message, in case I run out of time, that I want you to walk away with is that, Connecticut's family courts have evolved into an unregulated multi-billion-dollar industry that represents a real threat to public safety as it stands. We need meaningful reforms to the way the judicial branch does business because we need to maximize our tax dollars, protect state interests, and the workers in the courts. And we need to keep paramount the safety of these families. The need for these hearings is evidence that the family courts are incapable or unwilling to police themselves effectively. The family courts, some of the solutions that I want you to remember that I think are important are the family courts should not be allowed to accept public funding or enter into agreements which, A, are with vendors that are owned by judicial branch employees, such as judges, such as CSSD employees, and the people who appear before them on family court cases. That's number one. Number two is the court should not be allowed to participate in grant programs from on the state or federal level, which provide perverse incentives to discriminate against litigants on the basis of gender, to remove children from the care of safe and fit parents, or place children with identified predators and convicted offenders. Examples include the Responsible Fatherhood programs, the VAWA Safe Havens, HHS Access and Visitation, and other types of programs. These parents also strongly oppose shared parenting laws. And the reason for that is pretty simple. Shared parenting laws would require every offender and every predator to obtain legal and physical custody of their child victims, while eliminating or severely diminishing supports for the parent who might try and rescue them.
I'm sorry, I keep forgetting. You said you submitted written testimony to the website?
I did.
Okay.
And so my wrap up on this is just that, I feel like every case that I've looked at, and I've interviewed hundreds of parents, I've interviewed employees of the judicial branch, all of them fear retaliation. And all of them, the common denominator in all these cases is that they are somehow traced back to the Association of Family and Conciliation Courts, which has about 5 of your employees, Mr. DeTuno, who are running it, according to the Articles of Incorporation, which I've included with my testimony for everybody to see. And I think there's some accountability to be had if you don't know that 5 of your employees are running a court vendor. That's entirely inappropriate because these are very vulnerable families and they can't speak on their own behalf. And there are judges who are good judges that told me that they can't do their jobs and that they can't make the right decision because they fear retaliation. And when they have tried to speak up and make decisions that are in favor of children, they experienced professional retaliation. So I don't think it's a safe situation for anybody to be in.
Thank you very much, and we'll review your testimony. It actually isn't in our package here. I think this is just what was handed in.
Yeah, and I included my solutions in that as well.
Thank you very much. I think there are some questions, and I think, yeah, I'm going to actually just go out of order and let Mr. Titano go first since you specifically addressed him.
I don't know where you got your information, but I'm not in charge of anything that you have said here today, so I don't know where you got your information, but that's not accurate.
So you don't oversee the Family Services Court grants?
I don't oversee court grants. I oversee a court grant, but I'm a program manager. I'm not an administrator. I'm
Right.
So
So
I'm in
because-
charge of 5 AFCC people. I'm not.
Okay, because my understanding was that Deborah Kulak answers to you?
That's
Is that-
inaccurate.
Okay, because
That's inaccurate.
I can submit that email if maybe we could just correct that. Yeah, okay. Because I got that information directly from CSSD.
I'm sorry, I think Mr. Weissmuller was first and then Representative Gonzalez. I apologize.
I did have a question. You said that, I'm keeping my notes on my little iPad here, and maybe I heard you wrong. You said the court should not be permitted to dedicate public funds to vendors owned by court employees.
Yeah.
It's kind of a touchy question to approach because, you know, in one respect, I don't want people to be harmed by what you say. So I'm going to ask first, how is it that you believe you know that is happening?
I've included for you the articles of incorporation, and during the course of writing these articles for the Washington Times, I got the vendor payments directly from the judicial branch to show how much they'd been paid, what they'd been paid for, and those things.
Did you include some kind of? I did see one. I did in all of the documents that I've reviewed. I did see several documents related to a company where a board of directors is listed. That was the AFCC.
Mm-hmm.
Right. Did you include any materials in there that show that the court is paying the AFCC some kind of money? I didn't see that.
I didn't, but if you'd like to have some of that information, I could definitely turn that over to you.
Okay.
An example I could give you would be that in, I think it was March or April of 2013, they had the Connecticut AFCC conference held at Quinnipiac. And the conference was put on by AFCC Board of Directors member, Judge Linda Monroe. CSSD, now these are people, I want you to understand that they get paid a salary by the state to do a certain job. And one of those jobs is to train court employees. So they're already on a salary. But what happened here, according to the judicial branch, was that they gave these employees paid education days and then paid for them to attend a conference which was sponsored and put on by a company that they sit on the board of directors for. And that seems to me like it's awfully indicative of kickbacks.
Well, I don't know that it is. I'm going to throw myself on a sword, maybe. But I was on the board of directors of the National Criminal Justice Association for several years. That's an association where basically there's a gubernatorial appointment from each state, and then there's one appointee to represent federal Indian land, and there's one appointee to represent the island territories. I took vacation time from my position as a judge to go and participate in NCJA meetings between the Department of Justice and the various state advisory people.
Right, but we're talking about they paid fees for people to train themselves. So in addition to giving them the day off, the judicial branch paid the admission fee to the corporation that they started. And, you know, it was one thing, but the other thing is the legal status of this corporation was at that time, I'm not sure what it is right now, I haven't checked in a while, it was highly questionable. They've been kicked out of, the AFCC had been shut down by authorities in various states for, you know, failing to comply with regulations. The IRS had shut them down. Different states did. And they never really, they'd been doing business in the state of Connecticut for 30 years, but they hadn't registered since 1985, I want to say. They withdrew Anthony Salias from the judicial branch. I've included those documents too. He withdrew their registration, which is why the Secretary of State opened up an investigation into their activities in 2013.
Okay, I want to. I guess I'm not going to ask any more questions on it because I'm fearing that I'm inviting supposition instead of something that might support the statement. Because the statement, if it's accurate, that I don't believe the court should be dedicating public funds to private companies where money is going back into the hands of the judges necessarily. There are probably some rules on that, but and that would.
I don't know that it goes directly to the judges.
Okay,
I just
now
know
that
that
would
it
probably
goes
be
to
important.
the corporation that they themselves run, and that they do this on the public's time. So, and we have evidence of that because Mary Lou Giovannucci sent emails from her CSSD account advertising for the AFCC. So
Mary Lou doesn't work for CSSD. Mary Lou doesn't work for CSSD.
Since when?
She works for court operations.
Okay.
Yeah.
Well, that's heartening. Thank you.
Well, I think the point is, and I think that Mr. Weissmuller made it, is we're hearing a lot of supposition, and it would, and we're hearing a lot of contradiction. So, Representative Gonzalez, you had a question. Are you finished, Mr. Weissmuller?
I had a shared parenting question.
Go ahead.
Your shared parenting question, I think it kind of threw me a little bit. I don't know that there's ever been a statute, and I did look at the proposed bill last year, and I don't think it's the legislator's place right now to order that if there are two people, they have to end up with 50-50 custody. That seems like you'd be trying to overrule the judicial branch. The judges obviously are there for a reason, and constitutionally they're empowered to try and protect citizens, try and protect children. They, in fact, act in their capacity to protect children when they are trying to make sure they maximize the time with each parent. They're protecting their emotional needs. But I don't believe that anyone should be trying to direct the judicial branch to say, hey, no matter what, it has to be 50-50. For example, you have an abusive father that is beating children, and he should be taken from them or removed from them in some capacity. I have to concede that I've probably done that far too many times in my own career. I've had to remove parents from their children because they were harming them. A parent who would sodomize his son, I made sure that he couldn't see his son until, and ultimately they reconciled when the son was much older, and many, many years of therapy on both sides. The court has that job. It always will. I don't believe anyone has suggested that the legislature pass a law that would take away the power of the judge by forcing parents to participate on a 50-50 basis. I believe the suggestion was a presumption that when two people enter the court, they would expect that they shouldn't fight too much because they might end up with 50-50 unless there's a reason to veer from that
Okay,
position.
well, I think there already is a presumption of shared custody, and I think we've heard the legal advocacy agencies speak to that point. And I just want to point out that this is not a functional court system. So what happens is these parents are going to the court seeking help, and what they're told is they have to co-parent with people who are violent offenders. And one example would be, Joshua Komisarjevsky, who, he had a child with a girl who was 15 years old back in 2002. And he went to jail and was termed a violent predator. And court services, not court services, the Department of Parole helped him with his custody case, and they encouraged him to sue his ex. And so he started suing for custody from his jail cell. And, Connecticut judges actually gave him joint custody. And when he got out, a couple weeks later, He went to the court. He was wearing a GPS bracelet on his ankle, and the court awarded him sole custody. And when his girlfriend, I guess his ex-girlfriend, went to try and get the kid back, she was, they delayed the hearing. They're not looking for this kid, and they're just saying, oh, you're just an alienator. And this kid was in real danger because only a few weeks later he went out and killed the entire Pettit family.
Ms. Stevenson, I'm going to ask if you can try and narrow your comments to have something whatever to do with the issues before the task force.
Okay, well, let me just say that I'm just saying that we already operate on a thing. Well, all the shared custody in terms of what he's talking about would require victims to litigate more from a position of not having child support or not having as much support. And that is a real concern of the domestic violence agencies who have previously testified.
Okay,
So-
thank you. Are there any other questions here?
I do. I just want to say in Connecticut, there's not a presumption of shared custody. That's why the task force, that's one of our charges. It's a presumption of joint custody.
Fair enough.
Anyone else? Minnie?
Thank you. Thank you. During that study that you was doing on this issue, do you find often abusers get custody of all those people that you interview? Do you think that a lot of them, the abusers,
According to the National Association of Judges, violent offenders get custody, specifically male offenders get custody over 70% of the time when they ask for it. And I think that in those cases, the reason why it happens is because when you have a kid who's in a dangerous home, that's a golden opportunity to appoint a bunch of people. It's like a billing gold mine because they can appoint a bunch of people onto the case or have them, quote, agree, and then endlessly evaluate, endlessly bill for advocates, GALs, and all these professionals who have no incentive to put the child in a safe home because then the money trail dries up. So I think that's a big concern that all these parents have raised.
Okay.
Well, I'd be interested to see those statistics. I find it hard to believe that victims of domestic violence lose their children 70% of the time. I don't think I would have a job.
I don't know that
if
they
were
lose their
true.
children. I know that abusers obtain custody, not sole custody.
That's just the flip
Yeah.
way of saying it, that the abuser is getting the child, so the victim is losing the child.
Yeah. I've included that citation for that in my testimony.
Unfortunately, we don't have that testimony.
We'll get it, but we don't have it written.
Oh, we don't have a testimony?
She's apparently emailed it in, but it didn't. It's not in our packet of the written testimony, which we've been provided for just now, but we'll get it. Any other questions?
Thank you.
Thank you, Ms. Stevenson.